what you argue.
But if on Monday the court rules in favor of the appeal, does that mean your client is bound to be liable to be detained under the ISA immediately?
Well, it depends on the order that's made.
Okay.
My personal view is that this court, and I think this is sub judice, so you have to be careful about this, but I don't think that the court has power to order a rearrest. At most, they can say that the order is valid. And then it is for the minister to do as he thinks appropriate. And the minister may well say there's no need to detain him anymore or whatever. That's entirely within the minister's domain. But my view, I think my team supports this view, is that this court has no power to order a rearrest. Of course, the government may take the position and may ask. I don't know. They've not indicated to us.
Is it because the issue is now academic or?
Well, it's strictly speaking, no. It's because what the appeal here is only about the order having been declared invalid, habeas given. So the appeal is against that. So if the court agrees with the appeal, then the court is saying that the order is valid. But then there are questions that come up as to whether or not that means the minister can detain under that order. That is not clear because it's not been queried before in court. So and that is one of the things we're looking at.
It's not clear at this point.
It's not, I don't think it's clear, but of course my friends from the government may say otherwise.
Can you explain why court no power to order?
No, because unlike an arrest in an acquittal, where the High Court acquits in a criminal proceeding and the appeal court reverses, in that situation, the Criminal Procedure Code gives specific power to the appeal court to order the rearrest. In the ISA, it's silent about that. And the CPC is also silent.
The only power to arrest lies with the minister.
With the minister and the police. Yeah. So if the minister wants to give effect to the order, but there are cases in the past where the Supreme Court has taken the view that once it's reversed, like in Karpal Singh's case, that order becomes valid again. So, but that's 1987 Lalang. So a lot of things have happened since then, and so arguments have matured, and I think there's a lot of room for argument there.
But in terms of legal recourse, if they rule in favor of the government who are saying
the minister,
is there any other further legal recourse?
Well, if Petra feels that there is a scope for review within a limited, because now the limit, and I agree with this, the scope for review is very, very narrow. If there are reasons within that narrow scope, then there's always the option of applying for a review. But until that is done, then the order of the court will be valid. So that's where the issues will basically fall.
Thank you.
But I think it's important for you all to explain what happened this morning insofar as the two-man panel and so on and so forth, and the sequence of events.
Thank you. Thank you.
He accused himself, he's already on some news sites, and that's not true. He didn't. You're be clear about that.
Yeah.
No, he recused himself from hearing the recusal of Republic.
Yeah.
Okay. The hearing of the recusal application, he did not sit on that application. So if you want to say he recused, it's only for the purpose of that application to recuse himself. He should not be deciding whether he should recuse himself or not. That's what he said, which I think is correct. I think he did the right thing. But I have my doubts about whether the way they carried on as two judges was correct in law. That is the part that I'm a bit uncertain about.
As of now, today, he's in.
Yeah, as far as, and that's why he sat on all the applications after that.
One more last question. If all the applications were dismissed, so do they think we have explanation? No need. So pretty much.
They are the Supreme Court.
Thanks.
But there is a code of the judges' code, from what I remember, says they should give explanations of their decisions. So in the previous cases, what I've seen is when they deliver the main judgment, they may write about these applications as well. So they may still do it. I'm not sure.
So as of now, most of it are being dismissed. Are there any more new things?
The last thing was the Guns testimony last Thursday, which they said was not relevant. I'm not sure. Without marriage.